Before I start, I was handed a piece of paper with a question on it. Would you advocate a self-neglect or hoarding specialist within each local authority, was the question. My short answer is yes. My slightly longer answer is that I think each safeguarding adult board, particularly after devoting this conference to self-neglect and hoarding, should actually be talking with agencies about what is the prevalence of self-neglect and hoarding in our area. What's the prevalence? Which agencies are involved? What are the challenges that these cases present? Because what kind of specialist or group of specialists that you put together may well depend on the prevalence and the manifestations of self-neglect and hoarding locally. So, for example, I know that in one local authority area there is a GP and a community matron who are commissioned by the CCG to provide healthcare to people who self-neglect and hoard, who may not be registered with a GP practice, perhaps because they are itinerant, and there is an evidence base that local authority has and CCG has to the effect that this is a good form of outreach. One or two London boroughs are currently experimenting with a specialist service to deal with hoarders. So rather than just sending in environmental health to declutter and deep clean, to try to work alongside people who hoard in order to try to understand what the origins of the behaviour might be, because if you don't understand that and you simply deep clean and declutter, the danger is that the referral comes back through the front door 6 months down the line, and you're back at square one. I would certainly advocate specialist mental health provision, whether that's through a hoarders group or cognitive behavioural psychotherapy or some other kind of mental health provision. A lot of people who self-neglect, particularly people who hoard, have a background of mental health issues, and there is a dearth in many places of CCG-supported mental health provision over the medium to longer term. There is some emphasis on short-term therapy, but that might work for some individuals, but a lot of these individuals need more medium and longer term. And then lastly, I'm aware of one county council that did employ a number of specialist social workers and community psychiatric nurses who worked as a team to deal with the very complex cases of self-neglect and hoarding that other teams had struggled to manage, and that service was directly line managed by the Assistant Director for Adult Social Care, and a very high level support from a very strategic manager for those kinds of very complex cases. And that service was created because of the work that had been done on what's the prevalence here, what kind of cases are we really struggling with here. So the short answer is yes, but there is a longer answer, and I think each safeguarding adult board might usefully invite agencies to contribute to the planning that might result in that kind of service being commissioned. So, having answered that question, I hope reasonably well, we'll move on. So, mental capacity. Number one theme in thematic review of SARs in London, equal number one theme of a thematic review of SCRs and SARs since 2013 in the Southwest, the references for which are at the end of these slides. So mental capacity is up there as a really challenging issue. I was asked a question as to whether people who whether mental capacity and people who self-neglect can happen. In other words, challenging the idea that actually it's only adults without capacity who can self-neglect. Adults with capacity can self-neglect and hoard. And one business manager, in relation to a SAR I'm currently writing, and I've talked about it already, the amputee, said to me, the Safeguarding Adult Board in this county council is really struggling to persuade adult safeguarding colleagues to do Section 42 inquiries on people who self-neglect and hoard who have capacity. If they're still struggling after I have written my SAR and presented it to the Safeguarding Adult Board, then I failed, because I do think that there is a place for Section 42 inquiries and multi-agency risk management meetings and so forth in respect of adults with capacity who self-neglect. Anyway, more of that now. So, a timely reminder, I hope, that capacity assessments are decision-specific and time-specific. How many safeguarding adult reviews have I read, when, including one yesterday? This individual has capacity, and I'm thinking, when was that assessed? Answer, 2011. Right? And in 2016, 2017, 2018, people are still saying, well, the individual has capacity. Right, we need to knock that on the head. I wonder when the last time a Safeguarding Adult Board in this locality or this particular region did a multi-agency audit looking specifically at capacity assessments. How often are they decision-specific and time-specific? And brackets, do they include an advocate when necessary to pick up something else that I said before? There's also something, and it's on this slide and it's on the next slide. What do we mean by impairment? How's that understood across the network? How often do I read SARs where I read something like, well, there was no evidence of an impairment of mind or brain, therefore we didn't do a capacity assessment. And I'm wondering, how in-depth was that assessment of, is there an impairment of mind and brain? How do we know? Or are we actually just running as quickly as we can to determine that an individual has capacity, because we then think there is nothing we can do because it's a lifestyle choice, and so we go on. A point I particularly want to draw your attention to is executive capacity. You're, I hope, all familiar in the room that the requirement in the Mental Capacity Act is, does somebody understand the information? Can somebody use and weigh that information? And can they make a decision? How often in your experience do you find cases where people can talk about a decision, but they then don't do it? And if you experience that, how often then do you factor that into conversations that you might have with that individual around assessing their capacity, with particular reference to use and weigh? Any OTs in the room? Who's going to own up to being an occupational therapist? No pressure, I promise. This is not a test. Are there really no OTs in the room? Okay, there are no OTs in the room. Right, fair enough. I'm not sure I believe you, but anyway. Why was I singling out OTs? Okay, I'll tell the story as to why I'm singling out OTs, and take my phone out so that I accurately measure time this time. Right. How do you do capacity assessments? He says, throwing out a rhetorical question. Bit much to ask audience participation, about 200 of you in the room. I suspect if I were to ask you, you would say something along the lines of, I have a conversation. You use verbal language. and you have a conversation with somebody. How often do you follow up that conversation, not just with triangulating what is said with what neighbours or family relatives or other professionals might say, which is again a link back to the previous presentation, but how often do you ask the individual to show you? Or as I think I've described it on one of the slides, articulate and demonstrate. The reason I singled out OTs is that every time I have asked an OT, how do you do a capacity assessment, we eventually get to the idea that OTs have been trained to ask the show me question. So, yes, I know how to make a cup of tea. Show me. Yes, I know that when it is cold and wet and blustery, as it was this morning when I set off to get here, on the last stage of the journey, I know what to wear. Show me. My father, who is 90, who doesn't self-neglect, but is in other respects an interesting individual, not least for the disgraceful newspaper he reads. No, Daily Telegraph, actually. Third political point. Apologies to anybody who is of that political persuasion, see me afterwards. But seriously, if you asked him about how he manages, depending on whether he liked you or not and how open and transparent he was prepared to be, he would talk to you. And he might talk about the loss of sensitivity in his fingers and his hands as a result of mistreatment for carpal tunnel syndrome quite a number of years ago, and also the onset of arthritis. If you asked him to show you how he fits his hearing aids, how he does his shirt buttons up or tries to, how he does his shoelaces up or tries to, how he makes a cup of tea or tries to, you would get an altogether more nuanced perspective. And if you were to ask my sister, who lives 5 miles down the road from him, I live 120 miles from him, spot the family dynamics, she would equally give you a much more nuanced perspective than he might. Show me, a really important part of capacity assessments, partly because of executive capacity. And at the risk of tripping up over GPs or medically qualified professionals who are in the room, although I think I'm right in saying this, the part of our brain that controls our ability to talk about decisions is different from the part of the brain that governs what we do and how we manage the consequences of what we do. So you may well be having to do a capacity assessment in relation to an individual who can talk the talk, but by virtue of frontal lobe disturbance or some other kind of disability is actually not able to execute the decisions that they are minded to take, or indeed to manage the consequences. Alongside of that, there may be individuals who actually can talk the talk but don't act, but they may not be acting because their decision-making takes place in a relational, social, and environmental context. So the individual who was the amputee, the district nurses were saying, well, you're not housebound because you can use a wheelchair. And he said, yes, I'm not housebound because I can use a wheelchair. I've actually not been out of my flat for the last 6 months because actually the wheelchair is inaccessible, but yes, I can use a wheelchair. So you would go to the GP surgery to have your legs and your stump bandaged and your wounds treated. Yes, I would go to the GP surgery to do that. I could do that. But he didn't. Which meant that on some hospital admissions, he had untreated type 2 diabetes, and he had untreated sepsis, and he had maggots in his legs. Now, that might not have been because his executive capacity was in some way constrained or disabled. It might simply have been that actually he couldn't implement a choice which he might have been prepared to implement without support, and because the environment was a barrier to him getting out. Was that factored into ideas in that case about lifestyle choice and about whether or not he had capacity? No, it wasn't, because his capacity was assessed in 2011 and it was determined he had capacity, and no one bothered to reassess it. So, for all sorts of reasons, don't rely on the written word. Don't rely on the spoken word. Your assessment needs to be much more nuanced than that. And I've put a Court of Protection reference up, GW versus a local authority, if you want to know just a bit about that particular case. And I'm a nerd, I really like case law, because I think we can learn an awful lot from case law. GW had Huntington's chorea. She is in a nursing home. The local authority on behalf of the nursing home has applied for a deprivation of liberty order so that she does not go out of the nursing home unescorted. She has objected to that application for a dole, which is why it's ended up in the Court of Protection. She argues that she is perfectly capable of keeping herself safe if she were to go out of the nursing home unescorted. And she can talk about keeping herself safe. And the judge decided that on the basis of the verbal presentation, because she represented herself in the Court of Protection, he couldn't possibly decide whether or not to make a dole. And so he conducted an experiment. He said, I want the nursing home to let her out, unescorted, but not unobserved. He made the deprivation of liberty order. Now, maybe that was because, in her case, she had a frontal lobe damage as a result of the Huntington's chorea, which was affecting her ability to execute and manage the consequences of a decision, but had not at that stage affected her ability to talk about the decision. So I suppose the message is a plea for something which is much more nuanced, and if you find that there is a discrepancy between what someone says and what someone does, or a discrepancy between what someone says and what other people say, that needs to be factored into your conversations about use and way. Lastly, before I leave this, I want to go back to coercive and controlling behaviour. It's not just victims, normally women, but not always, in relation to domestic violence, where coercive and controlling behaviour needs to feature. You need to think about family dynamics in cases of self-neglect and hoarding, where an adult who is self-neglecting is living with others. Because the requirement in the Capacity Act to reach a decision is a requirement that they must reach their own decision, not somebody else's. And a woman victim of domestic violence who says to the police, I don't want you to do anything, is that her decision or somebody else's decision? And there are cases of self-neglect, I'll touch on one in a bit, possibly. There are cases of self-neglect where somebody is assumed to have capacity to take a particular decision, where I would question whether in fact it was their own decision. Okay. Next bit of input is around this particular challenge. And this particular challenge relates to adults where you are inclined to believe that in relation to a particular decision at a particular moment in time, they have capacity. How do you respect their autonomy and their self-determination whilst also recognising that we all have a duty of care. And before I go any further, I want to say something about making safeguarding personal at this point. Making safeguarding personal requires that you ascertain the wishes and the feelings and the choices of the individual with whom you are working. And the presentation immediately before the cakes, and I am going to purchase a number of the packs that have been produced by service users here for Lewisham and for Brent, the two boards that I chair. So as soon as the packs are ready, I'm going to put in an order for quite a few in order to disseminate the work that has been done, because it's brilliant. It's important that you start with the wishes and the feelings and the choices of the individual, but that's not where you stop. A strength of the practice with the gentleman with the amputated left leg below the knee, there was clear evidence that various professionals at different points in time sought to ascertain his wishes and his feelings and his choices. But no one questioned the wishes and the feelings and the choices that he was articulating. No one explored them in any considerable depth. No one said, yes, but I've got a slightly different perspective, and I'd like you to hear my perspective. No one asked the next door neighbour who was supporting him for the next door neighbour's perspective and to see whether the two coalesced or in some way diverged. Making safeguarding personal isn't just about the wishes and the feelings and the choices of the individual. Don't stop there. You heard one of the two presenters, or in fact both presenters, when talking about the pack of cards, prioritise keeping people safe. All of us have a responsibility to contribute our ideas about keeping people safe, even if they are different from the ideas that are being articulated by the service user or patient with whom we are working. Why is this a dilemma? Well, it's a dilemma because, as a result of history, going all the way back at least to 1215, and a muddy field near where Meghan and Harry got married, known as Runnymede, from 1215 onwards, Magna Carta that is, all the way up to the present day, there is a very strong tradition that an English person's home is their castle, that we have a right, if we are capacitated, to take unwise decisions or decisions that other people might regard as unwise. We have rights in the European Convention on Human Rights, mercifully unaffected by Brexit. We have a right to liberty and a right to private and family life. And there is making safeguarding personal and the whole idea of personalisation in Care Act policy, starting with the wishes, the feelings, the choices. But on the other side, many of you in this room are registered professionals. You have codes of ethics. Your codes of ethics will talk about the duty to prevent, the duty to protect, and the duty of care. Extreme self-neglect compromises people's well-being. People have a right to life. People have a right to live free of inhuman and degrading treatment. Self-neglect can compromise both of those rights in the European Convention, and crucially, other people might be at risk. The individual with the amputated half leg, it's not just his right to private and family life and his right to life, it's the next door neighbours. He didn't have a functioning loo. He wrapped his excrement in newspaper. He used empty milk bottles for his urine. The house from time to time is recorded as being full of flies and very, very unpleasant smells that were percolating across and up and down. It's not just him who was at risk. But we know, not least because judges, including Lord Justice Mumby in this case, talk about, well, maybe sometimes the state is too keen to intervene. So there's a sense in which actually all of us are damned if we do and damned if we don't. If we don't intervene and something happens, the coroner will say, why the bloody hell didn't... Oh, sorry, I swore. Why didn't you do something? And yet if you do try to intervene, A High Court judge or a Court of Protection judge might say, you're being paternalistic, you're being overprotective, you're making somebody miserable. What's the point of making somebody miserable? That's the bit in this particular slide that is in red and slightly larger font. So it's a dilemma. So I'm going to tell you a story. And it's a story about a real woman called Manuela Sykes. If you Google Manuela Sykes versus Westminster City Council, on the front page of Google, and I did this last week just to check that it still works, and it did then, scroll down until you find a reference to the Court of Protection judge's judgment in Manuela Sykes versus Westminster City Council. So what's the story? She's an older person. She is prone to dementia. She has dementia. She is prone to self-neglect. She has a tendency to fall. After a period of self-neglect and a serious fall, she ends up in hospital, and after hospital she is discharged to a nursing home. The local authority, on behalf of the nursing home, applies for a deprivation of liberty order because Manuela is talking about and making efforts to leave the care setting in which she has been placed, and her nephew is advocating very strongly that she should be allowed home with the best continuing healthcare package that the CCG can fund, supported by the best care and support package that Westminster City Council are prepared to fund. The CCG and Westminster City Council are quite prepared to fund pretty much what might have been necessary, but are concerned that if she returns home, she will be at significant risk of harm, and are therefore supporting the local authority's application for a dole. So it ends up as a contested case in the Court of Protection. If you want an example of what I think is a really good best interest decision, it is the Court of Protection judge's judgment. You learn an awful lot when reading that judgment about Manuela Sykes. She had lived in this flat pretty much all her adult life. She was a single woman. Her only relative was in fact her nephew, who visited periodically but lived some distance away, hence the importance of the care package that the CCG and the local authority might be able to put together. You learn that she was passionately committed throughout her adult life to her local community in Westminster. You learn that she was a Labour Party councillor in Westminster City Council for a considerable number of years, which must have been singularly unrewarding if you know anything about Westminster. I suspect she probably, reading between the lines of what you learn about Manuela Sykes, she probably would have been a member of Momentum and would have voted for Jeremy Corbyn. Whether or not that recommends her to you is a lifestyle choice. You learn an awful lot about her. And the dilemma facing the judge is, do I allow her home? She will be happy there, but she will be at risk, even with the best care package that the two authorities can put in. Or do I make a deprivation of liberty order? She is safe in the care setting, but she is unhappy. What do I do? It requires nuanced decision-making. It requires conversation. It requires deep reflection. How often in your capacity assessments are you enabled by your organisations to do that? And how often do you do? There's a slight sidetrack before I tell you what the judge decided. There will be cases where, given this competing imperative or this dilemma, you're not sure what the right answer is. You don't know what the right answer is. And I would say two things in relation to that. If a case that you have worked with ever finds its way into the coroner's court, or scrutiny by the local government ombudsman, or scrutiny by a High Court judge in judicial review. They are not interested in whether you got the right result. They are interested in the quality of the decision-making process that led you to the decision that you made. Scrutinize your records. How clear are they about what led you to a decision in a particular case? That might be your professional values. It might be your knowledge. It might be the skills that you used in a case to apply your values and your knowledge. It might be the quality of the multi-agency work that you did. It might well be informed by what the service user or the patient said to you, accompanied by what others said about the choice facing that service user or patient. It's about the quality of your decision making, and if it ain't written down, it didn't happen. But the second thing is, if it isn't clear to you what the right decision is, then go through a process that enables you to reach the least wrong decision. The judge faced at least two possibilities in this case. He could make a deprivation of liberty order. She's safe but miserable. He could send her home with the best care package possible. She's happy but at risk. Which is the least wrong decision? And if you're faced with those kinds of cases, you might articulate how many options you think there are. You might write out with your multi-agency colleagues and with your supervisor, really important that, all the advantages and all of the disadvantages of each particular possible decision. And then you look at the advantages and the disadvantages and how they have stacked up in relation to each possible decision, and you take out of the framework the decision that you like least. If you started with 6, you're left with 5. You repeat the process. You remove 1, you're left with 4. You repeat the process. You remove 1, you're left with 3, and you keep going until you arrive at the least wrong decision. And you record all of that, of course, because if it ain't written down, it didn't happen. The judge sent Manuela Sykes home with the best care package that the CCG and the local authority could put in place. Ordinarily, when you use case law, you don't find out what then happened. And indeed, you won't find that on Google. But some months ago, I had the privilege of presenting on adult safeguarding to a seminar organised by the Court of Protection, to judges and solicitors and barristers who do that kind of work. And I talked about Manuela Sykes as a really good example of a best interest decision and the kind of balancing act that I would expect to read if I were ever called upon to do a SAR where this particular dilemma or competing imperative was very evident. And unbeknown to me was a Court of Protection judge sitting in the audience who came up to me afterwards and said, "Do you want to know what happened next?" And I said, "Of course I do, because then I can tell people like you." She survived for a number of months at home with the support of the nephew and the support of the best care package that could be provided until she ended up in hospital following another period of self-neglect and a fall. And she ended up back in a nursing home, and at that point the Court of Protection made a deprivation of liberty order, and then several months later she died. So we actually do know what the outcome was, but that's not the point of the story. The point of the story is the quality of the decision-making that all of us engage in whatever role we occupy. I've touched on lifestyle choice quite a few times. Remind me, 13:45 I'm finishing, aren't I? Right. Good. 20 minutes. Okay. Help. Right. As I said in the first presentation this morning, if anyone ever says to you this is a lifestyle choice, there is nothing we can do, question that. We're back to John McEnroe and the Spice Girls. Right? Okay. Is it really autonomy when you don't see or recognise how things could be different for you? You believe that there is nothing you can do to improve your situation. Life is hopeless. Everything is out of your control. Is that really autonomy? Is that really a lifestyle choice? Are we promoting somebody's autonomy if in that situation we close the case and we walk away? Is it really lifestyle choice when your executive functioning is impaired in the way that I was describing a few moments ago? Really question any assumptions you make about lifestyle choice, and really question assumptions that other people might be reaching about lifestyle choice. There are then a number of safeguarding adult reviews where this particular tension between autonomy and self-determination on the one hand and a duty of care on the other, where that particular tension is highlighted, and I've listed some of them here. And you may remember that I talked about Mrs. A at the beginning or towards the beginning of the presentation earlier today, the woman with a broken femur who would not go into hospital to have her broken bone reset and who ultimately died of sepsis and other infections as a result of that untreated wound. But I want to focus on this one because I haven't talked about this one yet, and I resisted the temptation when a newly qualified social worker asked me a question. Wandsworth, WWF, Safeguarding Adult Board, Safeguarding Adult Review. Why WWF? It's because she left most of her money to the World Wildlife Fund. WWF. So she's got multiple sclerosis. She's a lifetime smoker. She always lights her cigarettes with matches. She won't use a cigarette lighter. She has a tendency to drop lighted matches into her lap. She has a tendency to drop cigarettes into her lap. There have from time to time been burns on her body as a result of her being unable, because of her MS, to pick up lighted cigarettes and lighted matches from her lap. And she's not very keen on fire and rescue service advice about water sprinklers and fire-resistant blankets. For whatever reason, at the time she was being treated with emollient creams for skin disorders that were paraffin-based, and of course they are flammable. She refuses a suggestion that she should only smoke when health and social care workers are in the house. I'm going to smoke when I damn well please. Health and social care workers struggle bravely to try to persuade her only to smoke when they are present. There aren't any multi-agency meetings that look at the risks being run in that particular case. And if she does have capacity to determine when she will smoke and how she will smoke, how are those risks going to be managed? Oh, and she lives in a flat. So it's not only her right to private and family life, you know, and how mindful were we all of Grenfell at 12 o'clock, and rightly so. She went up in smoke. She dropped a cigarette when the health and social care workers were not in the flat. She was living in Wandsworth. So serious were the burns that she sustained that she was taken to Stoke Mandeville Hospital, which is in Buckinghamshire, quite some way north of London, which reduced the ability of family and friends to visit her because of the distance between the South London Borough and the Buckinghamshire Hospital. She died in hospital of the burns. I don't know what the right decision might have been in that case. I don't know what the least wrong decision might have been in that case. All I know was there are question marks about how all of the agencies worked together with WWF to seek to manage and mitigate the risks. It's an interesting review to read. That's the North Yorkshire case, so I won't dwell on that because I've talked about it. Again, it's a case where there weren't, if my memory serves me right, multi-agency meetings, certainly not a Section 42 inquiry about how do we in this situation manage the likely outcome of an untreated serious injury. The GP in that case, incidentally, was positively praised by the review for the efforts the GP made to try to persuade Mrs. A to accept treatment. Interestingly, in that case, one of the things that we do learn through reading the SAR was that she had been admitted into hospital several years previously for treatment, and she had gone quite willingly, but she had had a very traumatic time in hospital, and we don't learn very much about exactly what the nature of the traumas were, but she left hospital saying she would never go again. Lifestyle choice? Capacitous decision? Certainly something to be talked through with her. I wonder whether it ever was. And maybe something to be factored into a multi-agency conversation. Again, not prejudging necessarily the outcome, but just to say this is something that we ought to talk about because it's significant information. And then Mr. I in West Berkshire. This case was discussed in a multi-agency forum, so it can happen and it does happen in some cases. Good practice by the police, good practice by care staff raising concerns, mental health specialists consulted, legal options consulted. So here is a case actually where more of what good might look like was evident. So perhaps less of a focus on, well, maybe the agencies should have done something different in this case. So it's an interesting, balancing perspective, but still nonetheless some learning, not just about individual practice, but the context in which people are working. So the impact of workloads. And that links to something I said in the first presentation. Who looks after you? Who reflects on whether the workloads that you are carrying are manageable, are safe? Supervision not addressing the complexity of the case. What's the quality of supervision like for GPs, for practice nurses, for district nurses, for social workers, for social care staff? I qualified as a social worker in 1978. Around 1978, and certainly in the Barclay Report of 1980, the paucity and the poverty of supervision for social workers at that time was being talked about. And in my first 3 years as a qualified social worker, shut your ears at this point, newly qualified social worker, I had supervision on 2 occasions. It is an absolute disgrace that we needed a social work task force and a social work reform board in 2010, 11, 12, and then the Monroe report on top of that, to emphasise once again the importance of supervision, and not just for social workers, but across the piece. We're now in 2018. If supervision is still variable, as I suspect it is, then it is even more of a disgrace and an issue that we haven't cracked in 40 years of my professional life. What do SARs find? We're too accepting of lifestyle choice. There's insufficient professional curiosity. We're not asking people why people are taking or verbalising decisions in the way that they are verbalising them. Our mental capacity and our risk assessments are insufficiently robust. I go back again. Does your multi-agency policy and protocol for working with self-neglect and hoarding include templates for risk assessment not to be followed slavishly as if there's nothing else to think about, but simply as guides, as signposts to the kind of things that you might think about. The reluctance of safeguarding teams to do Section 42 inquiries. Oh, it's self-neglect, there's no third-party perpetrator. Or a mistaken assumption that the individual has to consent when the statutory guidance is very clear. You don't need consent for a Section 42 inquiry. Failures to escalate, and so on. Something else too here about rights and risks. Who decides? The individual, the state, some kind of combination. There's values implicit in everything that we do. As I said, Susie Bray is a colleague researcher of mine, but she's also my partner. If she were here and we were standing on this stage together, you would wonder how we'd managed to stay together for 30 years whenever we talk about adult safeguarding, in two crucial respects. When the Care Act was being debated in Parliament, before the Queen signed, there was a debate about whether social workers should have a power of entry in adult safeguarding cases. Susie believes, I think wrongly, that social workers have enough powers already, as do the police, and that no additional power is necessary. I think social workers should have an adult safeguarding power of entry. I'm right, she's wrong. Wales has one. Scotland has had one since 2009 as a result of a 2007 piece of legislation. There may not be many cases where we might want to exercise a power of entry if a magistrate is persuaded by the evidence, but there are cases where you are being prevented from seeing somebody who is at risk by somebody else, very often, but not always, a family member. The second area in which we disagree is how interventionist to be. I don't know whether this is a gender thing or not, but I'm much more interventionist than Susie is. That's where my particular value orientation would swing me to. The importance of supervision is that the supervisor should know that, so that the supervisor can scrutinise the decision which I might be minded to take in relation to a particular case. And if I am minded to intervene, of course my intervention must be according to law. And we have had local authorities that have kidnapped adults at risk. Milton Keynes versus RR is quite a famous case of actually where Milton Keynes City Council thought it was quite appropriate actually just to remove an adult who might have been at risk of financial and physical abuse because they were concerned, but they did so without any lawful authority, and then detained her against her will, without telling her son where she was, without conducting an adult safeguarding inquiry or investigation for a number of months, until barristers for the son threatened the Court of Protection. And at that point, the local authority did do an assessment, and ultimately the Court of Protection returned the woman home. It's a dilemma, and I need to speed up because I've seen Karen looking at her watch, and this time I'm not so subtly managing my time. Right. There are three strands to this: empowerment, protection, and autonomy. And everybody in this room will prioritise to a greater or lesser extent one of those three. In this slide, it might be autonomy that you prioritise. In that slide, it might be protection that you prioritise. And as I've identified, that's probably where I am as a starting position. Or it might be empowerment. I suspect Susie might be there if she were here. The importance is that none of these are necessarily right or wrong. They're just positions. They're orientations. And actually bringing everybody together, including your line manager supervisor, but bringing the other agencies together, is an opportunity to reach a more nuanced judgment that focuses on four key questions. And the 4 key questions are there. So my standard, again, for how, when I'm looking at SARs, in preparation to write a SAR, my standard for how close to good did the agencies get is how much clarity is there that these 4 questions were talked about and wrestled with and struggled with, and ultimately a decision recorded in relation to each. What recommendations do SARs reach in this particular area? Oh, I mustn't walk about, must I? Multi-agency risk management meetings, well, I've laboured the point, haven't I, really? Considering all the legal options, you can, incidentally, go to the High Court in relation to an adult with capacity and ask the High Court to exercise its power in inherent jurisdiction to safeguard and promote the welfare of an adult at risk, where you believe that that adult at risk is not making their own decision, coercive and controlling behaviour and undue influence, or is in some way disabled from making a free and relevant choice. You can go to the High Court. There are instances when the High Court will intervene when persuaded by your evidence. Regularly update your risk and capacity assessments and consider executive capacity. Record your decisions. And finally, if you are concerned about somebody's mental health, be really clear whether you are asking for a mental health assessment or a mental health... Sharon's mouthing the words. You're telling me what to say, aren't you, yeah? Well, you're not, but we're on the same page. Or are you asking for a mental health Act assessment? Because obviously the personnel you need for the Mental Health Act assessment are specified in law. So question choice, respectful challenge, carefrontational questions, not because you're trying to remove all risk, but you do need to have conversations about risk, not least with WWF about her smoking. Don't walk away. Don't abandon people. Too many examples in SARs of agencies just walking away. They've got capacity, it's a lifestyle choice, there is nothing we can do, we walk away. Please don't do that. That's not what good looks like. Some final points from SARs, and this is the last slide before you get to the references. Again, where are the strengths in Telford and Wrekin? Where are the strengths in Shropshire? Where are the vulnerabilities in your systems in relation to what I have presented? That's what you need reflective conversations about, in my humble judgment. Thank you very much.
Sarah Hollinshead-Bland, Service Manager for Adult Safeguarding at Shropshire Council. Thank you so much for today. You've completely been inspirational, and I know that we'll really be pushing, making sure that our staff see your presentation. It's very important they learn from you. One of the things that's also as court-appointed deputy for people without capacity to manage their finances, I struggle with is the balance of making the decision, the judgment about whether somebody can use and weigh against whether they're making an unwise decision, and making sure that we get that right. For instance, in a couple of situations recently, we have relinquished our role as deputy in the belief that people have capacities to make decisions and manage their own money. I've believed that we're being over-protectionist about the way we've taken control over people's lives. I'm now reflecting on a couple of those decisions around the use and weigh issue. And I'm just wondering what advice you have for me as a deputy and for our workers to actually work out the difference between somebody making an unwise decision and not judging them as lacking capacity for that, and genuinely being able to use and weigh and understand the consequences of the decisions they're making.
I think the Office of the Public Guardian could be a useful source of advice and support. Interestingly, in relation to the East Sussex case that was in the first presentation, the East Sussex Safeguarding Adult Board decided to send the SAR that Susie and I wrote to the Office of the Public Guardian. And the Office of the Public Guardian wrote back to the Safeguarding Adult Board to thank the Safeguarding Adult Board for doing that, because it prompted the Office of the Public Guardian to begin to have conversations within their own organisation about what more they could do to support attorneys, people with lasting power, etc. What more they could do. But I think the short answer, or medium answer, is have conversations. Interestingly, I'm writing with Susie again a safeguarding adult review for a SAB in the southwest. Relates to a woman possibly with learning disabilities who was inclined to give money away. And she rationalised that when asked by a tenancy support officer, well, that my religious faith tells me that this is what I have to do. No one really engaged with her in meaningful show-me type conversations in order to establish whether she did or did not have capacity to manage her money. People knew, for example, that she couldn't manage change, so she would always use notes, and she would get change from the notes. She probably didn't know whether she got the right change from the notes, and she would put the change to one side or give it away, and then in the next shop she would give another note. No one really factored that into conversations with her, supplemented by conversations with her brother and sister-in-law who knew her well, or indeed with other professionals about whether she had the capacity. So it's back to conversations, and particularly conversations that look at executive capacity as well as decisional capacity. Didn't happen in that case. In case I'm not asked any more questions or I don't have any more time for questions, because you're being a really good master of ceremonies, or person of ceremonies, I should say, I just want to make one plea, and it's to kind of misquote Churchill. Do not let this be the beginning of the end. This must be the end of just the beginning of a whole system conversation that you have about issues to do with self-neglect, hoarding, and mental capacity. Thanks so much. It's been a privilege.